So can we have Sanjeev Kapoor? Welcome, Sanjeev. Karan Bularia, Nishchal, Richie, of course, Mansi, you're there, so it's fine. So, please, okay. Anyway, while they are sitting down, people want some break, right? Okay. But what I would like to do is for each one of our panel members, I would request if they can introduce themselves a little bit, that would be wonderful. So, of course, Sanjeev, we all know that you are a senior advisor at MPR, but it would be nice as to what you've been doing and a word or two about other things.
Hi, my name is Sanjeev Kapoor, and currently a senior advisor at MPR. And for the people who don't know what MPR is, it's the only global association for private capital in emerging markets, and the members basically manage about $1 trillion across about 100 countries. My career has actually been for a long time only in emerging markets, investing both running a global fund of funds, direct Asian fund, and also an emerging market fund. So that's over a couple of decades. So I've seen a few cycles, both economically and politically. And I'm a firm believer that the sort of template that you need for India for investing, the much maligned minority investing for growth investments is a particularly appropriate way to invest there, as long as you know two things, which is who you're partnering with and why. And having done investments in that style for a very long period of time and getting the exits, profitable exits, I find it rather odd that people are always focusing in on the control, value-add templates, which probably are not as good a fit, and people who come with that mindset oftentimes end up in litigation. And it's all because of a mismatch of expectations. So I just wanted to leave that thought.
Thank you. May I request Tim Morris to join us, Propium Capital Partners. I'm sorry I made a mistake because your name was not in the original brochure, but we are honored to have you. And just for your information, I never commit mistake, I only commit blunders. So pardon me for that. And Tim, I would love to know a little bit about yourself, so if you can help give some background.
Oh, great, thank you. So Tim Morris from Propium Capital Partners. We started investing in India in 2006 and have done a series of real estate investments, both project level, entity level, pre-IPO investments in private companies, preferred equity investments, and straight debt lending style investing. And maybe I'll just pause right
Thank
there.
you.
We've been very active for the last 10 years.
So nice of you. And Karan.
Hi everybody, I'm Karan Bularia. I run the Goated Fund Management business in India. We're a real estate focused fund management group. Not been around for so many years, fairly young. We started about 4 years ago, investing focused only in residential equity across the country, and we continue to grow our business as we speak.
Thank you. And Nishchal? Or Richie, I'll take you later.
Sure. Hey everyone, this is Richie here. I head the fund formation practice at the firm. The practice focuses on advising GPs who are looking to raise India-focused funds across VC, hedge, private equity, different asset classes, etc. The practice also looks at regulatory aspects, including ODI, swap transactions, on the portfolio investment side. So look forward to having your participation in this session.
Thank you. Nishchal?
Hi, I'm Nishchal Joshipura. I'm the partner for private equity and M&A at Nishit Desai Associates, and I assist clients both on formation of the funds, investment in India, and on the mergers and acquisitions in India, both private and public.
So Mansi, you're already introduced, right? Yes. Okay. So thank you so much. So Tim, let me start with you a bit. What's India's weightage on your global asset allocation at this point in time? How has been your India investment experience so far?
As I'd mentioned, we started investing in 2006. We were actually part of the Morgan Stanley platform at that time. We've had a series of different types and styles of investments. We've had some great successes in some pre-IPO companies like Vikas Oberoi's company, which is now public, where we sat on the board while it was private and really tried to bring international corporate finance experience to that company. Tremendous success in that. We've had some difficult investments as well over that period of time, but net to the positive for our fund and our experience. Where we sit today, we have a new fund that started investing, first investment in February of 2014, and the first investment of that global fund was in India. We would be at about 30% allocated to India today, but as we stabilize over the next 2 or 3 years, I would think that'll be 10 to 20% will be allocated to India from our perspective.
Interesting. And Sanjeev, but how do you see fundraising environment now?
Well, I think it's better for India than it's been for quite some time. In fact, I remember maybe a couple of years back at an Imperial conference, there were more India panel speakers than there were attendees in the room. And that was 2 years ago. And this year, there were 2 India panels, one lunch, and right after that, another India panel, and both had standing room only. In fact, we were worried that there was too much India, but it didn't seem to be the case. So right there, if feet of interested parties, and these are limited partners, seem to be involved, and in fact, I got a call just the other day, there's a large pension fund out of Canada looking for someone to give money to in India because they're having an allocation problem. They want someone, but they want to give a very large sum, and they can't find people with track records that need the capital at this point. So I think it's probably the best time to raise an India fund right now in the last 3 years.
Before I come to Karan, Richie, what comment would you have for the GPs, fundraising for India? Would the terms be any different from, say, a developed market fund?
Sure. No, I think I'll take cue from what Sanjeev just indicated, that how the interest for India risk, the appetite for India risk had dissipated some time back, and now it's back in flavor. How the conferences recently focused on India could garner that much amount of attention from the offshore audience. So clearly, Indian private equity VC market today, is in a very different phase. What was earlier, sort of overestimated is now sort of underserved. So there is a lot of appetite to absorb capital again, and even the LP interest is back. As far as the terms are concerned, you would be pretty much allowed to believe that most of the funds, even though they are sort of focusing on Indian asset class, the terms tend to be similar to what you would see in a more frontier or a developed market. You would see the same 2 and 20, the same sort of the waterfall allocations, etc. The pinch is actually felt more by the first-time GPs, etc., who are on the road, either for their first fund or a second of the series of the funds, etc., which is where you sort of start seeing the flavor of an emerging market coming into the terms. The first one, of course, is on the management fee side. Clearly, the market is not at 2 anymore as far as the first or the second series manager is concerned. It is closer to 1.5. You see a lot of DFI participation in Indian sort of VCP funds in today's market. What tends to happen is if you approach with a sort of weaker management fees, it tends to give a very defensive sort of an outlook to the GP's position. If you get too aggressive, if the terms are very GP friendly, it stifles the momentum on the fundraising. The other aspect which sort of impacts the kind of terms that a GP would offer is also to do with the stifling of exit opportunities in India. What tends to happen is if you have a lot of assets which are in infrastructure or real estate, etc., an experience has been that the exits tend to be slightly longer. So what you have is the tenure of the fund pretty much being linked to what is the asset you're holding. There has been a lot of agitation between the LPs and GP. The GPs have not been able to get exits, and therefore the request to sort of have a longer term or allow the the GP to extend the tenure with, let's say, an IC sort of a confirmation. But of course the LPs tend to resist that. The third piece where we have seen a lot of India flavor coming into the term is on LP give back. Whenever the fund is being the vendor and selling an asset, and the sophisticated purchaser is on the other hand, they would want some protection against any tax bills coming up later on. The first option is clearly, can we escrow the part of the exit proceeds? Now that a GP or the vendor fund may not be comfortable for the simple reason it impacts the cash flows. The second option could be taking a tax insurance, but again, that has a cost factor and again negatively impacts the returns. The third clearly is an LP give back, where you pretty much as a GP ensure that right at the fundraising stage, your LPs are aware that unlike a typical developed market fund, in this sort of a situation where the expectations are linked to an emerging market, there could be protected LP give back provisions, not just 20-30% at the end of the tenure, but could be 100% of the distributions. Even the tail could be longer to about 6 or 7 years even after the fund term is sort of over. So a lot of those terms have a bearing when you're talking to first year or a second time fund managers. This I would think are the differences.
Interesting, I think. And Karan, you're able to raise your first fund in an environment that was really difficult. Of course, you've done a good job on that. And now you have successfully raised capital for the first close of the second fund, right? How have things changed this time around? What aspects LPs are looking for? If you could just give some comments.
Sure. So, in my view, first I just want to caveat that all of my views are related to real estate funds only, because that's what that's the business we're in. But as far as what we've seen is there is investor consensus right now that is very clearly favorable on the macro situation in India. There's no doubt there. So interest has come back. People want to look at it. They also think that there's interesting areas within each strategy, be it residential office or some of the strategics like logistics. There are interesting opportunities that exist in each of these areas. So investors are looking at investing in India at this stage. There's no doubt about that. However, I think I had a meeting with a LP yesterday who's been in India for almost 10 years now, and he did his first round of investments in 7 and 8, and now they're looking to come back again. And one of the comments he made was that the first time when they didn't get the expected return, risk-adjusted return that they'd expected, he could have blamed the GP. But the second time, he's only going to have to blame himself. So what he was trying to say, and I think is very true, is investors want to come back, but they're very cautious about how they want to enter India. They want to be very sure what they're playing, they want to know who they're partnering, and they want a good sense of what is going on. So the biggest topic, the biggest list of topics that they have that takes priority, number one is very clearly partner selection. So people want to make sure that they have the partner right. They're spending a disproportionate amount of time making sure that they've got the right partner. So a lot of effort is going into that. The second thing that is becoming a bit of a tussle and a bit of a dispute is where LPs want to have discretion over the investments that the GP is making. Particularly, they want veto rights. So they want to be able to pull out of things that they don't believe in. And this is becoming a bit of a strife. I think the good question is that we, in our first fund, did put out discretionary rights, but as we went into our second fund, we moved away from discretionary because now our LPs believe in us and they want to come back and give us more capital. So I think over the years, you'll see discretion going away, but for the short term, I expect it to be a big issue when fundraising starts. And the last point that I want to make is there's a dedicated effort from the LP community now to find ways to make sure alignment is there and there's high levels of governance and transparency. They don't want any opaque type structures. And within all of these points, in my personal view, I think the most important one to get right is the alignment factor. Because even if you have the right partner, the right strategy, and you're not properly aligned, there just remains areas for confusion.
Thank you. Just let me change the tax a little bit. And has anybody got any comment or question at this point in time? Because instead of leaving it to the end, if you want something to say now, feel free. As I mentioned, it's more like a square table. So we are on equal footing. But if anybody has comment or question, just feel free to raise now. We'll again have chance after everybody finishes, but I thought it may be a good idea to even have anything in between. Okay. So
one comment what Karan mentioned. In fact, a lot of pre-2008 funds which were set up, the model that the fund managers used to follow was to partner with multiple developers and do multiple deals. So in a, let's say a $500 million fund, they will do 8 to 10 deals with 8 to 10 developers. But slowly they realized post the Lehman crunch where a lot of major economies suffered and there was some pressure even on India, that it's better to partner with one developer and do 10 deals rather than partner with 10 developers and do 10 deals. And that's where we started seeing platform structures. In fact, we had set up the first platform structure for Godrej Properties and APG, which is the Dutch pension fund. And that model has been quite successful because you don't have to do the background check of 10 developers. You just rely on one partner and fully trust, and obviously that partner is going to, needs to be a very good brand in the market, like the Tatas or the Godrejs, which have a stellar reputation in India. So to that extent, there is a lot of certainty on the deal. You are relying on your partner and the specialization, and there is a lot of comfort in working together. And in fact, Godrej is a classic example where the Dutch pension fund had invested in the first fund, and there is another round which is happening where there are again multiple LPs who are willing to partner with them. So this is one big change which we have seen as far as the structure is concerned. The LPs want to be faithful to one partner as compared to partnering with multiple partners.
Thank you. Thank you so much. I spoke a little bit about the tax treaty issue and, Mauritius treaty under renegotiation, but because nothing is in the public domain. So, Mansi, I just want to turn to you. What in general, you look at what kind of considerations for, fund jurisdiction, Mauritius, Singapore, Netherlands? Can you give us some comments?
Sure.
Assume for a moment Mauritius treaty, nothing has happened, because I cannot hold you to that.
Sure. So when we're deciding the fund jurisdiction, of course, tax plays a predominant role to create a tax efficient structure, given, especially for US funds, direct investment is not something that is advisable from a tax perspective. We look at alternate intermediate jurisdictions where the fund vehicles could be set up. Now, it's not just tax, but there are also a lot of practical considerations which are associated with it, especially given the importance of substance which has been increasing internationally. For instance, where is the team located? What is the strategy, etc. So there's the whole picture has to be looked at while deciding which is the appropriate jurisdiction for each fund. But broadly, as Nishit mentioned, the jurisdictions that we have seen for investment into India have been Mauritius, Singapore, and Netherlands. These three are very popular. Just to speak a little bit about each, Mauritius has historically, of course, been one of the strongest jurisdictions. Time when the first funds were set up and investments were made into India, Mauritius has been used. In fact, our firm had played a very important role in structuring the few initial funds. So Mauritius since then has been has been the most used fund jurisdiction. In fact, more than 40% of the FDI in India has been made from Mauritius. Why it's so popular is because of the way the treaty is worded. You basically get a capital gains exemption, so you're not taxed in India, and Mauritius does not levy tax on capital gains, so that is a big upside for those investing into India. Of course, Mauritius has recently been in a lot of news and debates, as what Nishil had alluded to. There was a lot of, especially given that substance is being questioned and how India wants to impose GAR provision, etc. The question was whether Mauritius really has substance or not. But over time, and we have seen in several cases that the courts have recognized that Mauritius entities are not necessarily sham or set up for tax avoidance, and the route still works. The protocol, the treaty is being amended to include a protocol which has been signed. Of course, the details have not been divulged yet, but we look forward to having a strong protocol which is going to get even more certainty to the Mauritius route for investment into India. The other jurisdictions, of course, are Netherlands, which is, in fact, of late, we've seen more funds being set up, and more so because where Mauritius is concerned, it works for, say, an equity investment. But suppose it's a debt fund, or there's a mix of equity and debt, it's not always tax efficient to come into from Mauritius. So that's when we have of late been looking into Dutch structures, and like Nishchal had mentioned, they've been working very well. They give where interest payments are concerned, you can get a nice back-to-back arrangement with minimal tax leakage in Netherlands and a lowest interest withholding rate that can be achieved from India. And the last jurisdiction, and one that has become very strong, more so because practically we find clients are able to set up their teams and they have offices there, is Singapore. So practically they find very easy to be able to create an office and team and have presence in Singapore, meet the substance requirement. But of course, Singapore does not work for everybody, given that it has very stringent rules, and the benefit, the capital gains exemption, which a lot want to rely upon in the treaty, is dependent on a number of conditions, both locally and under the treaty. So there are various factors that need to be considered, and you need to look at the entire facts and circumstances of your particular case while deciding which jurisdiction works best for a fund.
No, thank you, Mansi. Just for the information of those who do not know historically why Mauritius came about, what had happened is Mauritius-India Treaty was signed in 1984, so it's almost like 25, 30 years now, and almost 30 years, right? What happened was the way in which the capital gains rules are written in the US and the way in which they are written in India are somewhat opposite to each other, as a result of which you do not necessarily get a tax credit for the capital gains tax paid in India against the capital gains tax payable in the US. So they are whole convoluted and kind of other kind of thing that you need to go through. And therefore there is a double taxation of the same income. That's first issue. And also it becomes more important for pension plans and other tax exempt entities if they pay tax in India and they have nothing to take credit against. So it's a direct hit on the returns. So this was there for a long time, but in 1991, when India signed treaty, did not resolve this problem with the US. So double taxation problem continued, and just about the same time, we were doing research and we found that this is a problem, and we were setting the very first fund for India and we tumbled on this Mauritius. We went to Mauritius, helped government of Mauritius to develop offshore financial center. It's a long story, I won't go into details. And set up very first fund, Bombay Fund Limited, Index Fund. The second one, also we set up Alliance Capital, India Liberalization Fund. The third one was George Soros and Chase Capital, fourth one. So, but all these first 4 or 5 funds worked, in terms of avoiding tax at India level. And there is no tax at Mauritius level. Mauritius does not tax capital gains. But when people bring money back to the US, still they pay tax at the end of the day. So the whole idea at that point of time was to avoid double taxation of the same income. Whereas most people thought that people are going scot-free. Therefore, you see a lot of news items to say that, oh, nobody's paying tax in India, nobody's paying tax in Mauritius, and that's a whole newspaper's story. But the real story is that when you bring back money to the US, you pay, but you only pay tax at one end. That was the basic background. In light of that, you know, this Mauritius treaty over a period of time became popular. In 1991, India opened up to the foreign investor first time. And, you know, things happen, and ultimately Supreme Court of India also ratified that there's nothing morally or legally wrong in third country residents like the US to come to Mauritius and set up company and invest in India. So that's how the whole process went on. And eventually now India is trying to introduce GAR and stuff like that. And India also signed a protocol with Singapore in which they also granted, Singapore went to government and said, oh, why don't you give us capital gains tax exemption? But government said, okay, look here, we'll give you subject to certain conditions, which are called limitation of benefit article. So that is incorporated in Singapore Treaty. And Netherlands always is the cleverest one in negotiating tax treaty. Any country in the world, if you see negotiations of treaty, Dutch people are the supposed to be masters at that, you know. So the Dutch-India Treaty provides that if a Dutch company owns 10% or less than 10% of the equity of Indian company, then it would not pay capital gains tax if it sells to a resident of India. But Dutch treaty also provides that if Dutch company sells shares of Indian company to any other non-resident entity, then also there is no tax. In case of sale to a resident, the rule is that if it is holding 10% or less, then there will be no tax. But if it is holding more than 10% and sells to a resident of India, then it does pay tax. So it has certain benefits. Then the limitation of benefit article is not there in Dutch treaty, so therefore Dutch is sitting quiet on the side. The other thing is that of all the jurisdiction, Mauritius is relatively the cheapest. Okay, so for startup, early funds and stuff like that, and you know, that's a good jurisdiction. Number two, Singapore is a little more expensive. As you know, it requires fund managers to obtain certain license, and it requires 3 employees to be employed in Singapore. So it's really $200,000. You calculate $500,000, $250,000 you pay in salaries and some other expenses that you have to incur. And one of the conditions in Singapore-India protocol is that Singapore entity should have incurred at least 200,000 Singapore dollars operational expense in 2 years prior to each of the 2 years prior to the sale of the shares. So that kind of condition exists in Singapore. So Singapore is being used by those entities who are able to put some substance in Singapore with employees and with people and ability to spend that kind of money. So I would assume that on an average $1 million, $1.5 million you should be able to spend every year. I think then it's the game is worth it. And Netherlands I already talked to you about. So, these are the factors that you really look into, and let's see what comes up in the new protocol.
Also just to add to what Nishit said, in addition to tax issues, the corporate law issues are also very important in these jurisdictions, especially if you look at Mauritius. Mauritius has one of the most flexible corporate laws for funds to operate. So in case you want to extinguish your 100% of capital on one day, it is possible in Mauritius. But the same is not possible in Singapore. In Singapore, if you want to, let's say, buy back your shares, you cannot do more than 20% buyback in one financial year. You cannot merge a Singapore company with a non-Singapore company, or you cannot merge a non-Singapore company with a Singapore company. So this is one issue which is creating a lot of problems in case of restructuring of Singapore-based funds or Singapore-based companies. As compared to that, in Mauritius, if you are a GBC2 company, and typically all funds are set up as GBC1 company, but it's not difficult to convert GBC1 into GBC2, and then you can merge a Mauritius company into any non-Mauritius company, or you can merge any non-Mauritius company into a Mauritius company. On top of that, the ease of administering the fund is also an important criteria. Mauritius, because funds have been set up in Mauritius, since 1991. There are experienced fund administrators who know how to administer a fund, how to calculate NAVs, and they are aware about the nuances and intricacies of fund operations. As compared to that, Singapore, if you see, is a relatively new jurisdiction for setting up of funds. And what we have seen is some of the clients complaining about the lack of knowledge of the administrators in Singapore. And there is a lot of time which goes in educating the administrators in Singapore on how a fund operates. So these are the things which may not be critical at least on the administration side at the macro level. But when you start operating a fund, these are the things which bother the GPs a lot. And that's also something with which the GPs and LPs should consider while choosing a jurisdiction for the fund.
Yeah. And as you know that India was to introduce general anti-avoidance provisions. That means if you undertake a transaction or a structure only for the purpose of tax avoidance, then you will not get the benefit. And that provision has now been postponed to 2017. And the way there is also grandfathering of anything done before 2017. So it's that's something India has done a reasonably good job. It created a lot of concerns in the last few years, but those concerns have been addressed. Nishal, one small thing here. What's the current impact of, what are the structural considerations when a GP is looking to raise commitments from both offshore and India-based LPs?
Sure. So I'll touch upon the offshore fundraising and what are the concerns for the GP. So typically all private equity venture capital funds have an Indian advisory office because on the ground presence is required to source deals. And one of the biggest issues which GPs face, both offshore and domestic GPs who are setting up offshore funds or pulling monies from offshore LPs, is the way the Indian advisory team operates. There is a risk of the offshore fund creating a permanent establishment of the offshore fund in India. So that becomes very critical, and basically the concept of permanent establishment is that you are operating in India through your agent in India, and generally most of the times the Indian advisory team, because it is on the ground, it negotiates most of the deals with the promoters or the developers, and it's very important on how they conduct the operations in the Indian advisory company and how they deal with the negotiations and the documentation with the promoters and developers. Because what we have seen sometimes is everything is done by the Indian advisory team, and only the final execution version of the definitive documents is sent to the offshore fund or the offshore manager. And the biggest risk with that is that that merely renders the offshore fund board or the offshore manager's board stamping authority as against a body which thinks independently of its own. Because when the fund is set up, the way the documentation is structured is that the Indian advisory team only makes recommendations to the board of the fund or the manager, and the ultimate decisions are taken by the board of the manager or the fund outside India. But all this is forgotten when the deals start happening, because the documentation is signed on day one, but the deals happen over the next 4 to 5 years. So typically both the Indian advisory teams and the board of the fund and the manager don't realize that in effect what they are doing is they are negotiating the deals, they are signing deal documents, they're signing term sheets, definitive documents, they're taking decisions with respect to the shareholder related approvals which are needed in case of reserved matters or affirmative vote items from India. So the small things become very important because the benefit of India Mauritius or India Singapore or India Netherlands treaty is available only to the extent the Mauritius, Singapore or Netherlands fund does not have a permanent establishment in India. And if these type of things are happening, then there is a huge risk for the offshore fund that there could be a permanent establishment for the offshore fund in India, in which case the tax rate could increase from 0% to 40%. So how you operate and manage your operations in India becomes extremely important. And given the fact that the tax authorities in India have also become very smart, 5 years back, they were actually 10 years behind the consultants. The way the structures were devised, they were not aware about what was happening. But in the last 5 years, they have caught up, and they are absolutely, in terms of being in line with the market. They know what structures are happening, what type of structures to attack, and sometimes they are even more proactive than the consultants. So it's very important that everything that is done, right from documentation to even actually the conducting the way the operations are done in the Indian advisory company, it's very important that not only in letter but also in spirit, some of the do's and don'ts are followed to avoid any permanent establishment risk. So that's on the offshore fund side. Other important thing which we have also seen, one of the major causes of litigation for the funds and their Indian advisory companies has been the transfer pricing issue. So what is the markup which is paid by the offshore manager to the Indian advisor for sourcing deals? That's also been extremely important, because typically the markup should be about 15 to 20%, but in some of the cases the tax authorities have been very aggressive and have even levied a markup of about 70%, on the premise that the activities done by the Indian advisory company are akin to an investment banker. And the investment bankers don't charge a markup of 20%, they charge a markup of 60 to 70%. So again, it's very important, same issue, how the Indian advisor needs to ensure that their activities are limited to being of recommendatory nature rather than being binding on the offshore manager or the offshore funds. And because ultimately the markup is a function of what are the risk functions and assets which are attributable to Indian entity. So if the Indian entity's role is minimal, to that extent the markup can be reduced. But if it is on paper and actually in conduct, the Indian entity is almost doing everything with the offshore entity not doing, or rather doing minimal things, then in that case there are chances that a higher markup could be attributed to India. Other issue which is a new issue as per which came out in this budget of this year is there is a new concept of place of effective management which has been introduced under the Indian Income Tax Act. What it means is earlier the concept of residency was that a company is a tax resident of India if it is incorporated in India or if it is wholly controlled and managed from India. That concept has been changed to place of effective management, which means that if there is a foreign company whose place of effective management is in India, then that foreign company could be considered as a tax resident of India. And the way place of effective management has been defined is if major decisions have been taken from India, then there could be a risk of place of effective management being in India. Now, one of the issues, there are 2 or 3 places where this could be an issue. One is there are a lot of carry structures where when Indian GPs have set up offshore funds, the head of the Indian advisory company typically have offshore carry structures where they have their own personal holding companies outside India. The question which could arise is because that personal holding company typically is held by an administrator, and when the carry is received by that personal holding company, there is a risk that that personal holding company itself, because all decisions with respect to personal holding company are taken by the Indian GP, that personal holding company itself could be considered as a tax resident of India. So even though income is not repatriated to India, it could be taxed in India. Another issue could be for large groups like Tatas and Godrej's of the world, where you are setting up your subsidiaries abroad, and in a lot of situations you always have an SPV in between the Indian company and the operating company outside India. In that situation, the risk could be that the intermediate vehicle, typically the decisions with respect to that SPV are taken from India. So the risk is that that SPV, which is set up outside India itself, could be considered as a tax resident of India because of this POEM issue. So this is going to result in a lot of litigation as far as the Indian, as far as foreign companies are concerned, which are being managed from India. It's important that suitable adjustments or suitable modifications are made to the board structure or the decision-making structure at the offshore level, in case there are members from India who are on the board of the offshore funds or the offshore companies. Another consideration which becomes important in situations where there is a pooling of money both from domestic and offshore LPs is for domestic funds, you have, for pooling money from domestic LPs, you have domestic fund, and for pooling money from offshore LPs, you have an offshore fund. The question is, would you want a parallel structure where offshore and domestic fund are parallelly investing in the same portfolio company? Or would you prefer a structure which is what we call unified structure, where the offshore fund pools in money in the domestic fund and then domestic fund invest in the portfolio companies directly? There are a lot of considerations for that. There are tax issues in unified structure versus a co-investment structure. There are also foreign direct investment issues where once you invest in a domestic fund itself gets colored with foreign money, and hence even the domestic money will be subject to foreign investment policy. There are issues on FIPB, because when you are investing in an Indian fund as a foreign fund, then you need a permission from Foreign Investment Promotion Board, versus a parallel structure where you are directly investing in the portfolio company. So broadly, these are the issues which are there when you are looking at pooling money both from domestic and offshore LPs.
I think you made very important points. The way in which I look at where things have really changed now, structure has remained more or less same, Like everybody knows there is a trust in India or a box you put in Mauritius, and on the top of it you have a Cayman company and stuff like that. What has really changed is the way in which you articulate a document. I think that legal language that goes into the placement memorandum has assumed, because tax department is not looking at a structure, bear in mind that. All the boxes, you do a nice job on the PowerPoint, but they are not looking at that. They look at what have you exactly written in your documents. That's one thing. Second thing they will do is to pick up your website. Many a times I have seen website would write, okay, we have offices in Germany, in Singapore, in India, and words like that. When you write word office, tax officer would pick up and say, oh, if it is a subsidiary, it may not be treated as P, but you are yourself saying it's an office. So first thing tax department would look at is your website should be very carefully written as well from Indian perspective. And third, commercial justification has become very critical to every document. So what do I mean by that? Is that because of the impending GAR provisions, and even though formally GAR will apply from after 2017, but in practice they begin to raise those kind of issues. So every time you write an agreement, make sure your recitals are very well written, because that is the story. What is the commercial justification for entering into that particular agreement? Many times people write agreement without proper recitals and straight away go into operational part. But the background, and that's where you need to bring about commercial justification. Every document you see, recital is the key today. Another thing that you might want to consider is that when you say set up a company in Cayman, that's typical for the US, then you set up a company in Mauritius, a fund company, and then you invest in India. Either Mauritius company will set up one more subsidiary or otherwise and get into India, right? So first question, why do you set up Cayman company, okay? And what will be your justification for that? I think the commercial justification would be The Cayman laws are very similar and understandable by the US investors. And investors are more comfortable generally in the US to deal with the Cayman company. They are somewhat familiar. But then when it comes to Mauritius, then why do you have Mauritius company? Why are you putting that, right? Is the tax only objective? The answer to that would be that Cayman or US do not have bilateral investment protection treaty with India. So when, as a fund manager, you invest in any country or any place, what is your first obligation? The first obligation is to see that you are not reckless or careless in terms of protection of investment. Capital gains will come as and when you exit, whenever you make profit, and of course tax has to be dealt with. But first thing is that in the fund manager, investment manager has a responsibility to the ultimate investor. Most of the time you have pension plans and others, they may have billions of dollars. Behind every pension plan there is a small person's money. So responsibility of fund manager goes back all the way to the small investor's money, and he has to see that somebody may offer 100% return, but is the investment safe? Now India and the US do not at this point in time have bilateral investment protection treaty, BPAR, you know. As a result, it is not protected against what you call nationalization or insurrection of currency or all those kind of adversarial rules. In Vodafone's case, as you know, these issues were taken up because changes happen, retrospective amendment, where is the protection? BIT is a protection. Bilateral investment treaty is a protection. So for that purpose, you need Mauritius. So it is Mauritius not only for the purpose of tax or tax avoidance, so to say, but also for, but all these things have to be incorporated in the documents or in the first board meeting of the company that you hold, and articulating that whole thing in the document gives you a robust commercial justification for using countries like Mauritius or Singapore or whatever. Even Singapore Treaty says that if something is done only to take benefit of Singapore Treaty, benefit may not be available. That's protocol, right? So now it has become more of an art. It is no more what I would call a structural exercise. It's more of an architecture's or architect you build around, right? There's slight difference between architectural work and structural work. So those are kind of things that you might want to consider, because tax has become a very critical part, and foreign tax is conceptually a cost. Domestic tax is considered obligation generally. So these are some of the things perhaps might be of interest. But Richie, I'll just take, I think we are slightly running out of time, but we'll still open up to the questions. Anybody has questions, please be prepared to ask. But Richie, last one for you from my side. What are the key issues driving alignment in LP-GP relationship now?
Sure. So I think, and just to keep the answer simple here, I think one of the key fund terms that LPs and GPs typically sort of negotiate upfront is on the management fee. The debate is just not over as yet. And other than asking like how much should it be, the question also revolves around what it should be. Should the management fee during the investment period be a function of capital commitment, or should it be a function of the capital contribution? That is the actual amount of money that was sort of drawn down by the manager and actually deployed in working assets. Post the investment period, the debate even gets more interesting. After that, should it be the cost of unrealized investments, or should I do a fair market value of the unrealized investments? That is what the ILPA standards are currently today. And given the significant presence of DFI investors into Indian private equity and venture capital markets, where IFCs and CDCs are more used to seeing global sort of nature of the terms, pretty much the side letters that are done between these DFIs or the first round anchor investors and the GP deliver not just customized reporting solutions, but also these key financial benefits that as an early round investor you would sort of seek to extract. And again, side letters are becoming more, smaller ticket size LPs are also accessing them. It's no longer a case of, let's say, if I'm an anchor investor controlling about 30% of the entire corpus, pretty much even a lower ticket size LP today wants to ride the same bus as a larger anchor size investor. So we have emergingly we are observing that most of the LPs are now, especially in the top tier bracket, they're saying that if we are coming with a particular size, then we don't want other LPs in the same bracket, so that our ability to move the needle as far as the GP is concerned, as far as taking views on different issues are concerned, as far as the alignment is concerned, we are the ones who can sort of drive the entire process forward, and not just be bracketed along with other LPs who may, for other reasons, not be amenable to something which is favorable to LPs as the larger group. The second piece, and I think I'll just also would like to summarize the previous points that were made on the forum. I think global standards on governance are increasingly being onboarded into Indian fund structures also. Despite having a discretionary manager who's managing on a blind pool basis, the board of the fund today has a lot more responsibility, and the jurisprudence is emerging from all corners of the globe. To begin with, the board today is expected to have a very detailed agenda come for the meeting. You should have taken input from the administrator, from the accountants, and everyone. The deliberations of the meeting that the board is having of the fund also should be minuted accordingly, so that if ever a question is raised that, okay, was the board exercising its mind or not, was too much of delegation given to the agent, the fund manager, accordingly the members of the board can demonstrate their fiduciary to the entire platform by saying that yes, the agenda was robust and the minutes reflected the mind that was applied. Should the members of the board also be remunerated in a manner commensurate to their efforts? The debate is out there, but that is the issue which is increasingly coming up. We saw a recent ruling, that came out of the Grand Court in Cayman in case of evening, where there was an instance where the fund managers had sort of tripped the limits that was placed. Let's say the fund cannot invest more than 30% in particular situations, not more than 25% in another sort of situation, and the manager had tripped those limits. The board in its agenda and the minutes could not catch that sort of lapse. What had happened, the Grand Court actually, penalized the directors and said that had you performed your duty, the fund would have maintained its particular NAV. Because you did not, the fund is at a different NAV. So the netting of the two NAVs, had you done your duty, is where the penalty is. Each of the directors were fined about $111 million. So that is the kind of governance standards which we are increasingly seeing. But just for your information, that ruling was of course overturned by the Supreme Court later on, when they said that, okay, to come up with these sort of penalties, clearly the default has to be of a willful character and something which the director deliberately did. But clearly the governance standards globally, including for India-focused funds, is heading towards the right direction where a lot of robustness has to be observed.
So they lucked out, huh?
Yeah.
I think must be a good lawyer, right? So, but I think the kind of things that are happening are not heard before, and the principles are very important to bear in mind. And of course, you are going to hear Professor Cannon on the new emerging standards of governance in the last session. So please wait before you go for cocktail, right? And let's open up to the questions if there are any questions, and we'll spend about 5-7 minutes on that. Slightly behind time, but it's a good time to even talk. All of you have come. I want to make sure that everyone gets opportunity. But before that, can I ask anybody on the phone wants to ask a question? Then we can give them a little chance. Okay, I don't think so. All right.
Okay. Maybe I will go first.
Yeah.
This is Vaibhav. I am partner with Nishit Desai Associates. Tip question for you. I've not worked with you, so maybe this is, I should have known this, but your fund has been very active in India and has a lot of investment in India. Three questions actually. First is, what made you attract to India? Second is, what risk do you allocate to India in terms of what are the risks you see in India? And third is, how do you mitigate those risks?
So obviously what attracted us to India was essentially a global sort of top-down theme, which was we looked for emerging markets, particularly emerging middle class. And as a real estate fund, our view is real estate largely tracks GDP growth. So when you have high GDP growth environments, combined with the benefit of urbanization and emerging middle class, if we can find real estate products that house, feed, recreate, give places of work, that's going to be a long-term trend that we think is, in all likelihood, in India it's a 20 to 30 to 50-year trend that at least in our investment horizon over the next 10 to 20 years is a good top-down call. There's going to be cycles. So that's what attracts us to India. Now, we've been investing in people and resources in our team in Mumbai for coming up on 10 years, and so we have a high level of confidence in the individuals that we have selected to work with us, that we've trained up, that we think are first-class, professionals. We spent a lot of time meeting a tremendous amount of people in the market. I mean, we probably punch above our weight with the amount of meetings that we do versus the amount of deals that we do. So we've definitely got a very good sense of the landscape, who the promoters and developers are. And then the partners of the firm spend a lot of time. Myself and the other founding partner, who's based in Singapore, we're in India quite often. So we take a great interest in the market. In our 10 years, I don't think there's been a better time to be looking at India. GDP growth, 7-8%, higher than China, first time in 16 years. Inflation, mentioned earlier, in the target zone of 5%. Foreign reserves at 400 billion. So there's just a lot of good. And then you layer on the leadership that's in place from the government, the initiatives that are pro-business, the momentum. The time is now to capitalize. The fear in India is everything happens in India, just maybe not exactly in time and on time. And so the great fear here would be this would be a missed opportunity if people don't capitalize on this opportunity to implement a lot of and capitalize on the momentum. From a risk perspective, I think the biggest risk that we have seen is just timing risk. That's been our experience. I think there is a lot of potential, fraud, which was mentioned earlier, and corruption. I think you need to weed that out in your due diligence process with the people that you're partnering with. But the big issue that we have seen is just things happen. They just take longer than promised. And so we've learned over time to align ourselves with the promoter in the structure such that the penalties, it's painful. If they articulate, here's the business plan, then we give them 25% more time, and then things start to clip on them that are painful. It's amazing how focused they get to help resolve the issue or move things forward. So that's been the big risk that we've experienced, I would say, is just time. And we mitigate that largely through structure. It's something that we do. Our fund is a fund that makes minority investments around the world. And so we probably made 90 investments globally in over 16 countries. So we invest in a lot of different countries, minority investments, and it's the due diligence and the structuring that mitigates the risk.
Thank you. Yeah?
Hello. Thank you.
Your introduction, please.
Sure. My name is Maria Fringa with Amicorp.
You can take it closer. Yeah, it's okay.
My name is Maria Fringa with Amicorp, and we're in the business of corporate tax structuring. My background is I'm Dutch, and I'm an international corporate tax lawyer.
You're smart.
But so it's great to hear your outline about the use of Dutch vehicles in tax structuring. But I have a question. You mentioned effective place of management being taken up in the Indian tax code. And my question is, does it challenge where the GP as a vehicle, or where the GP would be situated? If you have a fund in the Netherlands, does a GP need to be established in the Netherlands by definition, or can a GP be exercised, a place of management be exercised from the US? And would that challenge the Indian take on whether that would jeopardize the treatment of the fund in the Netherlands in any way? Open.
You want to say?
Yeah, I can take to some extent and let you know. See, it's a very interesting question, first of all. Two things happening. One, you have a domestic law, which talks about poem, it's called. It's not that beautiful, of course. A poem in Indian context is place of effective management. And, it has become kind of a little terror word in some ways, that if there is any management that effectively happens from India, then that foreign entity is deemed to be tax resident of India. That is how it is, right? Now, when it comes to treaty situation, what happens is that there is something called tie-breaking rule. So because of the rules in one country, a company may be resident of US or Netherlands, okay? India has treaty with both the countries, basically, okay? And if there is a tie-breaking rule in a treaty, that even if to some extent the effective management, so-called, the way in which it is defined under Indian law is in India, but at the end of the day, they take a call in light of the tie-breaking rule. Okay, so if company happens to be tax resident of both the countries, then there are certain factors that are evaluated and has to be taken that, okay, it should be regarded as a company of a particular country resident. And then you can get over the poem kind of situation. Poem has become a little tricky. Of course, government has issued some more clarification, and they are going to issue more clarification, because if you have little control in India and a foreign country company becomes a tax resident of India, it will be taxed on worldwide income. It will be a big issue, and that would not work in the globalized world. So where is the real control and management, and whether it is a resident of 2 countries or more, those are little complex issues. But just to tell you that only because company has a so-called place of effective management only in one country doesn't make it necessarily so. Like in the US, you only look at place of incorporation. You do not necessarily take into account the place of effective management. If foreign company has some kind of effectively connected income, ECI, then you are taxed, of course, but not because a foreign company is managed or controlled or otherwise. So that's what we saw. Anything else?
No, I think so. The location of
because
GP doesn't matter as much as the decision making which happens outside India. So even if the GP is India based, but your let's say the Dutch fund has a robust board with independent directors, and the Indian GP is just a minority on the board and does not have any veto rights, to that extent the poem risk would not be there in India. Whether the actual decisions are taken outside of Netherlands and not in India, it becomes a question, as Nishit mentioned, of whether that particular entity will be considered as a tax resident of Netherlands as per the local Dutch laws. And based on that, whether a tax residency certificate will be issued by the local revenue authorities, but that per se will not have any impact from an Indian residency perspective.
Yeah. Any other question? Okay.
I have a question.
Yeah, please, sorry for
You
No.
alluded briefly to the changes, potential changes in India-Mauritius Treaty. Is there some more color you can give on that? What are some of the things that could
I
change?
will be colored. Okay. I cannot speak about it, but I read out statement of the Minister for Financial Services and Good Governance. I think that's all that I can at this point in time talk about. So, let's wait. It may be in a week's time or 10 days. Hopefully something should come out. Let's see. Even I have not seen final text because it's very strictly guarded. And, although we advise and we do a lot of things, but final text remains. And so cabinet is to clear, and then we can look at it.
I guess I have one more question. For people from outside of India who are on boards of companies, what kind of liability protections are needed? Is there anything special that is needed? Which
Well, I
from Indian
think
perspective?
the board members' liability is getting little trickier day by day everywhere in the world, and particularly India as well. India standards were so loose that anything and everything went, right? And only way in which possibly you can do is to have good D&O insurance. Okay, be a little careful. Very important thing. I think Richie talked about the liability, right? So the new standards that are coming up are those that say that it is not what you do at the time of the board meeting. It is what you do in between 2 meetings is also very important. So you have to be engaged directors. You see, if you do not do that, then also liability could come in potentially. Okay. So it is better to take fewer right directorships than just trying to do number of directorship as used to have with the case at one point of time. So, unless you can devote enough time and attention to the company's affairs, you should be just careful. Maybe Richie, you want to say a word or say?
No, I agree. I think more in the fund context, given where the fiduciary lies. See, I think the whole genesis starts from the fact that in an LP sort of arrangement, where your investors have no voting rights, unlike the traditional company format where you are holding ordinary shares and hold voting rights. The LPs are pretty much holding illiquid asset classes, completely, their faith's relying on what the GP does, what the board does. So the amount of fiduciary that a director owes in a fund context is at a very different level than as opposed to, let's say, the traditional company format. So like you have activist hedge fund investors who are, trying to get towards more shareholder-friendly terms, distributions of dividends, etc. Clearly, the impact on the fund industry also, as far as the directors are concerned, there's a lot of jurisprudence out there. A lot of it is still emerging. You have some of the leading courts, the Chancery Court in Delaware, the Grand Court in Cayman. They are delivering path-breaking and new jurisprudence is emerging from there. I think to be a director today, you have to be, absolutely in sync with where the jurisprudence is heading, and make sure that you keep yourself up, and up to the speed of what is expected from your role as a director. I think that perhaps could be the best way of ensuring yourself.
Yeah. And as I mentioned, Professor Cannon is going to speak on that subject in the evening. It will be nice to interact with him as well. Anyone has any question, or we can have our, guest is waiting. Where is Jack? Oh, Jack, I was looking for you. Okay, sorry for a little delay. Thank you so much, Jack. So may I request you to come and talk to us? Then I think let's give a big round of applause to our entire panel. I think they've done a fantastic job.